call the next case.
In re Lucas S.
May it please the court, my name is Anthony Kirby from the Montgomery County Bar Association. I'd like to reserve 3 minutes for rebuttal, if I may.
All right.
This is a termination case involving one child. We went to trial on multiple days for this scenario as well, which seems to be a common theme in front of your honors here today. As we went through, the issues started, in my opinion, before we got to the final hearing, and those were issues 2, 3, and 4. I'm going to skip over issue 1 because I will stand here and say that I made a mistake at this point. Obviously, when we're doing these briefs, we're going back and looking at a year past in time. There was a reason for why the case did not move forward in December of what would have been 2023 at that point, in terms of the courthouse being shut down for natural disaster at that point. No order was done. It was never reflected in the record. By the time we go back, does not recall. So
are you saying you're waiving that issue?
we're going to waive that issue of issue number 1. So instead, I want to focus on the related issues, like I said, of 2, 3, and 4 for right now. At one point, as we're going through this, my client, the appellant father in this matter, filed a motion for visitation on August 7th of 2023. We eventually went to court on that on October 5th of that year. And when we come forward on it, we find that there was, in fact, a court-ordered parenting plan. That court-ordered parenting plan had been ordered through the juvenile court, and that had been entered by an agreement of the parties, and that had not been modified in any way whatsoever by the juvenile court. It was presented in response to my motion for visitation in front of the trial court in this matter. As such, once presented with that, I withdrew my motion. There is nothing else on the docket other than a response by the adoptive parent, mother, and the guardian ad litem. But in terms of motion pending before the court, there is nothing else pending. Still, instead of being allowed to have visitation as what would have been prescribed under the court-ordered parenting schedule, it was determined that my client, the father, should only have telephonic visitation, and that would be it. To be frank and to be clear, the parenting plan provided certain parenting time to my client. The parties testified about the parenting plan and stated that it was mainly put in place because of the mother needing certain financial support through the child support aspect so that she could buy a home. Father entered into that by agreement. They hadn't followed it, but it was still a valid court order at that point. We go through, again, I withdraw my motion. At that point, we still have a hearing, and an order is entered. I argue, under this point, that it was done sua sponte by the court. If we don't have a pending motion before the court asking for a specific remedy, it has to be considered sua sponte at that point. And we look at what would be a Freeman v. Freeman on this issue, and it states that a trial court cannot go through and have any sort of sua sponte modification of a permanent parenting plan. Now, even if we go past that, and this court determines that it wasn't sua sponte, that there was enough on the record to reflect that there was a request for this not to be followed at some point, we now have to look at Tennessee Code annotated 36405B, which states that if a modification is to occur, which again, this was not a modification, this was a termination case, but if a modification of a permanent parenting plan order was to occur, that it has to occur with the parties' agreement, which was not happening in this case. That's exhibited by the by the record plainly, we had withdrawn our motion. We wanted the visitation. We had filed for visitation. We wanted my client to be around the child. And then, if we don't have agreement, we have to look at likelihood of substantial harm. The order of the trial court did not touch on likelihood of substantial harm. Instead,
You said you filed for visitation.
Yes.
What pleading did you file?
I filed a motion at that point through the trial court.
Okay, a motion for what?
Motion for visitation by father.
Okay.
Yes. Now, when we go forward and we look at the actual order coming from the trial court, the standard that they used at that point was best interest. That it was in the best interest of the minor child for father to have visitation for the minor child to not have visitation with the father, otherwise allowed about the permanent parenting plan. The trial court further found it was not in the minor child's best interest for father to exercise any in-person visitation, whether in Colorado or Tennessee. That was the finding of the court. As such, my client received phone calls only. We now go forward about a month in time, and we look at whether the trial court now erred in stopping those phone calls. Now we come back, and there is a motion by the guardian ad litem, and we talk about whether or not it was appropriate for those phone calls to continue. The two bases that we have there on whether these phone calls were going to continue were whether or not there were, what was the language there? They were not going well, as alleged, and that the father criticized the minor child when the minor child wished to leave the phone call. Those were the two bases that were proven in the record and put on the motion in front of the court. The appellees in this case didn't file a motion themselves, but they did join in and said that they supported the motion by the guardian ad litem. Came out at that hearing that mother had in fact recorded the phone calls in between father and the minor child. Those phone calls were not played at that hearing. Those phone calls were later shared. No testimony was had. There was no sort of expert testimony in any of these proceedings where it stated that there was a psychological harm to this child in any way by either seeing the father in person or by having telephonic contact with the father. What happened was that we now just have a cessation of any and all contact whatsoever.
Can you tell me, I'm sorry, can you tell me when that occurred?
When we look at that, I have it down as the order being entered on November 7th. It would have been 2023, I apologize. I put in the heading, I believe it was 2024,
Okay.
But it was November 7th when that occurred.
All right, so all of both your issues 2 and 3 then referring to the telephonic visitation and then the ceasing of the telephonic visitation, those are both in the fall of 23.
Correct.
Is that correct? Okay, all right. I was confused about that. Go
And then
ahead.
we have this idea of we were supposed to go to trial at that point. That didn't happen. That got moved. Obviously, we had the 2 days later on. Now we come forward and we look at and for my position, and when it talks about the cessation of any and all contact whatsoever, I look at Byers v. Young, which is a Tennessee Court of Appeals case from 2010, and it states specifically that juvenile court was presented with evidence of behavior by mother that would justify the elimination of any parenting time for mother with the party's child. Indeed, in the absence of a compelling reason to do so, an order which precludes contact between parent and child is to be studiously avoided, as the inescapable effect of such an order is the untimely death of the parent-child relationship. That's what we have here. We have a valid court order. We have a valid petition that is putting in place in terms of the termination and asking for a termination, but there has not been a decision of termination yet. But because of the rulings that we have leading up to the final hearing at this point, we now have, as this court has already said, the inescapable effect of an untimely death of the parent-child relationship between the child and the father at that point.
How long had it been since the father saw the child before this petition was filed?
Before the petition had been filed, he had been out of the child's life for about a year. And this is a child that is 8 years old, even at this time. We had, again, on the same related issue, filed another motion after the continuance of the originally scheduled final evidentiary hearing. And now we get to the idea of trying to reinstate visitation, whatever that visitation may be. And at this point, this is where the court now relies on In re Traylon, let me make sure I get this correct, I apologize. In re Tylon LD. And for purposes of this, I'll refer to it as Tylon. This is, again, a decision that was made by Tennessee Court of Appeals May 18th of 2011 and cited to in all briefs. The trial court, I should say, relied on this seemingly exclusively. And what happens in that is not analogous to what we have here in any way. First and foremost, the underlying cause, legal cause that we have in Tylon is a dependency and neglect action. It's not it becomes a termination case, but it starts out as a dependency and neglect. And we have a finding of dependency and neglect in Tylon, which we do not have here. Now we move forward and we have an order wherein custody has already been granted to a third party in Tylon. Again, something we do not have here. Now we look at whether or not there should be an established parenting schedule in Tylon. That's what the mother in Tylon was asking for, was for the court to establish a parenting schedule. Not to modify, not to enforce, not to do anything else, but to establish one. That is a different standard under Freeman. That is a different standard under Tennessee Code 366405B that we talked about earlier. It is our position, and I'll touch on the best interest factors and the grounds and how we got there in my rebuttal here in just a moment, but it's our position and why we spent so much time in our brief that this was a case of termination that was biased against my client, not because he's a male or not because he's father, not because of who he is as a person, but the legal findings that led up to the final hearing essentially, under the guise of what we've already had ordered through this Tennessee Court of Appeals, had already terminated his rights before we even got to a final hearing and had a decision made. Thank you.
Good afternoon. May it please the court, my name is Stacy Turner from Montgomery County, and I represent Shanette and Sam Binkley, who are here today. And what is unique about this case, and what I disagree with Mr. Beauchamp, who argued the first appellee case before the court today, when he said that text communications don't reflect accurately the relationship between the parties. I disagree with that wholly. This case is unique because my client had her text communications with the father from the date of this child's birth in July of 2016 until the final hearing in March of 2024. It was 823 pages worth of communication, and it was very reflective and very informative about the relationship not only between the mother and the father, but the father's efforts or lack thereof to maintain a relationship with his child. My client, who is incredibly organized, put together month calendars on one page that had each month, and we had the text messages attached to them so that we could tell, and she color-coded them, when there was a text, who initiated the text, when there was a FaceTime, when there was an in-person visit, and the text messages behind them corroborated that evidence. It was a stunning piece of evidence, and what was probably most stunning from my perception of that, I've been practicing for 32 years, I've never seen that kind of text communication as evidence in a trial. It was 823 pages, and the text communication from November of 2021, which was the last time the father saw this child, until we filed this petition in January of 2023, was 3 lines on one page. 3 lines. He hadn't seen him in 13 months when we filed this petition in January of 2023, And then when we filed this petition in January 2023, he didn't again even attempt to contact until July, on his birthday, July 16th of 2023, some 6 months later. This evidence, in our opinion, was a great deal of what the court relied on in its findings of fact. The court wrote a 16-page opinion with 35 findings of fact, extensive findings of fact that were thoughtful, that were reflective of the evidence that was presented, and she actually referenced the text messages and the calendars in her opinion in doing so. What is important for this court to know is that the father was in the military, and even though he had some trips through his military service that took him away from the child, there were many times that he would just disappear and go out of sight that are reflective on the calendars and the text messages that had nothing to do with his military service, and took him away from the child. Now, what these exhibits show and what the court found, that during the first few years of this child's life, when the father was in Tennessee in his military service at Fort Campbell, was that they actually co-parented very well. They entered into this parenting plan that was ordered by the juvenile court at my client's insistence. My client found a lawyer here in Nashville, filed the petition, got the agreed parenting plan, presented it to the father, and he signed it. At the time that Mr. Kirby came forward and filed his motion for visitation in August of 2023, the father did not even know the parenting plan existed. Not only that, they never operated under it. And it gave the mother wide latitude. It had the father having 0 days. It gave the mother wide latitude, because she was breastfeeding at the time, to see how that went before the father could eventually, at some point in time, get into an overnight, every other weekend parenting plan. But it's not disputed at the time that he filed his motion for visitation, and at the time we filed this petition, the father had never, not one time, had an overnight with his child, who was 7 years old at the time of trial, not 8. The first 3 years of his child's life, the court found that they co-parented relatively well. But in May of 2019 is when the father, who was in the military, went to flight school in Alabama. And he was there from May of 2019 through September of 2020, 17 months. And the court found in its findings of fact that the father only had 3 short visits, day visits with the child during that 17 months. Yet during that 17 months, the father was able to take trips to the beach, to Disney, to California, to Rhode Island, to New Hampshire, to Maine, to Massachusetts, to Georgia, and to Alabama. That did not include the child, nor did he try to visit with the child when he could get away for those occasions during his flight school in Alabama. The father graduated from the flight school on September 10th of 2020, and he came to Clarksville for a visit with the child that included 3 days in a row, day visits, no overnight. That was September 20th, 21st, and 22nd of 2020. Then he transferred to Colorado. And the trial court's findings, which are presumed to be correct in this appeal, the conclusions are reviewed de novo, but the trial court's finding, those 35 that are extensive in her 16-page opinion, are afforded a presumption of correctness. The trial court found that in September of 2020 is when the father's communications with his child became very limited. Few texts, few FaceTimes, and only a couple of in-person visits. That's demonstrated by the text messages and the calendar. There was one visit that he had during that period of time, a Florida visit, that my client initiated. That she set up, she and her girlfriends were going to Florida with the child, and she said, "Why don't you come here and join us and see Lucas?" There were many times that the mother facilitated a relationship and visitation between Lucas and the father. And the father testified at trial, and one of the findings of the trial court in this matter, that the father testified the mother never thwarted his visitation. That is in the trial court's findings, and that's in the transcript. When this petition was filed on January 23rd of 2023, the father hadn't spoken to my client since December 11th of 2021 and hadn't spoken or seen Lucas since November of 2021. even though he had also testified he'd went on several trips that did not include Lucas. Mr. Spivey testified at trial that he admitted that the mother, not only did she not thwart his visitation, but that Lucas did not know him as his father. He agreed to that, and he testified that he knew that that was the fact. Mr. Spivey did not send any birthday presents to Lucas from age 4 to 7. That's in the court's findings. He didn't dispute that. Did not send any Christmas presents to Lucas from ages 4 to 7. That's in the record, and Mr. Spivey did not dispute that, nor did he send any letters. My client, Sam Binkley, who is the stepfather, on the other hand, he is the person who Lucas knows as dad. He is the person who has raised Lucas in Mr. Spivey's absence. The court went at length to make findings about Mr. Binkley's testimony and how he has raised Lucas and how close that they are. Everybody who testified about Lucas, there was my client, Mr. Binkley, my client's mother, who knows Lucas very well, testified to his idiosyncrasies. That's kind of what they called it. My client, Shanette, said that he had been diagnosed with ADHD, but most likely he probably could be on the spectrum based upon his behaviors. He's very close to his mother. He doesn't like to be away from his mother. He has, food texture type issues, very particular issues that would prevent him from getting on a plane at 6 or 7 years old, unaccompanied minor, and flying out to Colorado for a visitation with his father. Those things were considered by the court. These are just a few of the 35 findings of fact that this trial court made in its 16-page ruling. And again, those are afforded a presumption of correctness. The court, in its conclusions of law, used these findings of fact to find that Mr. Spivey had in fact abandoned Lucas with his behavior over the years, most definitely the 4 months prior to the filing of the petition, but looked at the overall perspective from the text messages and the calendars from the time of Lucas's birth and found that he had abandoned him, and we would ask this court to affirm that decision. The issue number 1 about the tornado was waived. I'm glad about that. That was a little tongue-in-cheek, I think, in my brief. I knew Mr. Kirby had forgotten we had a tornado and the courthouse was closed, and that's why we had to continue this trial on the first time that it was set on December 11th. With regard to the visitation motion that was originally filed by Mr. Spivey, it was filed on August 7th, and it was heard on September 12th. And at that time, we had a trial date on December 11th. So the court found that because Mr. Spivey didn't even know about this parenting plan, didn't even know it existed, never operated under it, and had not seen this child in such a period of time, given the child's behaviors and idiosyncrasies, it's probably best to just do some phone contact pending the final hearing. And we started that. Because Lucas was 7 and he had a whole lot of trouble staying on the phone with his father, and many times he hung up on him, we had someone there facilitating the phone call, not my client, another person. And yes, they were recorded because there were problems. This child was having behavioral issues. He'd hang up on the father. He would want to get off the phone. The father would not let him get off the phone. And it was creating behavioral problems. We presented those to the guardian ad litem, and the guardian ad litem filed the motion, which we thought was appropriate. That motion was heard on November 7th with a trial date of December 11th looming. And so the court date said for this next, not even a month, we're just going to cease these for right now until the final hearing. The final hearing did not go on December 11th because of the tornado. We quickly tried to reschedule it and all agreed on March 11th and 12th of 24, which is when we had the final hearing. After that initial missed court date, Mr. Kirby did file on behalf of his client to reinstate that visitation, and the court rightly used, in my opinion, In re Tylon LD in determining resuming phone contact, again with an upcoming court date, was probably not in the child's best interest, and she denied that motion. We think that that was appropriate at that point in time. With regard to the conclusion that Mr. Spivey had abandoned the child. I think I've covered that already. With regard to best interest, as this court knows, the legislature amended the statute, I think it was in April of 2021 and maybe July of 2021, with regard to the best interest factors in a termination case, which are much more child-centered. This court was very thoughtful in its findings and found many of them didn't apply, but found A, B, C, D, E, H, and M did apply in favor of termination, only found that one factor applied and not in favor of termination. We disagreed with that, but we feel like the court did its duty, made an appropriate ruling, and it should not be overturned. Do you have any questions? Thank you.
I want to go back to this relationship that father exhibited prior to. This is not a situation, and I agree with opposing counsel on this. They were able to communicate fairly well while everyone was in Montgomery County, Tennessee, Middle Tennessee area, as long as father had visitation based upon what mother wanted to give father at that point. That often included coming to her work, coming to her place of residence. There were times where he asked for more. There were times where he traveled out of state to provide what would have been, as the record shows, essentially childcare for mother, and he would get a hotel room at the same hotel that mother is staying at, and there's still no overnight visitation. He asked for overnight visitation, and he's denied. One point during the trial, mother admitted that at one time she should have granted overnight visitation, yet she never did. There is case law which states that a parent does not have to physically stop someone from being around a child in order to interfere with that relationship to such a degree that it does not mean and does not constitute willfulness. We have year after year after year of these text messages, and I'm not going to go through all of them because they were admitted into the record and they're part of the record. But we have year after year of these text messages where my client is attempting to be a part of this child's life, and there's always a roadblock. At first, it was the breastfeeding. Then it became even not breastfeeding all the time, but breastfeeding partial time. And then it became, well, he's co-sleeping. Then it became, well, I'm not prepared to be away from the child. There's always something that goes on. And so eventually, a parent in that position, to their credit, gets demoralized.
Did he ever file anything asking for any type of court relief before the petition to terminate his rights was filed?
Not before the petition to terminate his rights was filed with the court. No, Your Honor.
And he had 0 days, correct?
He had 0 days for purposes of the child support calculation through the parenting plan, if I recall correctly, and I don't have the parenting plan in front of me. Through that, he did have certain time allotted to him, and it was specifically built in, I believe, that once breastfeeding would stop, there was some additional time that would be granted.
Any overnight visitation?
I believe that it is in the parenting plan as overnight visitation, but there has to be getting past a certain point with the care of the child and breastfeeding. That was a major particular player in what the parenting plan was submitted under through the juvenile court.
So, and maybe I'm just not following you. You said 0 days for the purposes of child support, but are you saying the parenting plan says something different?
The parenting plan would allot him visitation, yes. And even though there was parenting time allotted under the parenting plan, there was 0 days put down for purposes of child support. And the front of the page, when you look
So
at the
is that addressed in the parenting plan? When there, would that be a downward departure that's in the parenting plan then?
it's not specifically addressed. We have
Or, I'm sorry, an upward departure probably.
Yeah. We have a 0 day on the front page, and then we go through and we have an actual visitation schedule after that. It was the way that it was drafted up.
So the order is just inconsistent within
The
itself?
order is just inconsistent within itself is what I would say.
In the
Is-
trial court order, the trial court finds that the father testified that the mother didn't thwart his efforts to visit. Is that what your client testified to?
He did say that the mother never thwarted, may have been the word stopped, denied him that sort of visitation. It was on cross-examination. I would submit to the court that the record itself shows that he's asked for time otherwise and has been denied. But maybe there was an alternative that was proposed. Hey, I would like to have visitation over the weekend. You're not going to have the weekend, but you can have from this time to this time. Or you're not going to have overnight, but you can have throughout the day. You just need to bring the child back by this amount of time at the evening.
And is that all something that's in the text messages?
Correct.
Okay, so not in any type of petition or pleading?
It would have been in the text messages leading up to the petition being
I mean, he didn't ask, as Judge McGee asked, he didn't ask for
Not
relief
for-
from the court.
Correct. Those were all through text messages between the mother and the father at that point.
And is the parenting plan that you were referencing earlier, is that in our record?
I believe it is. It was provided by opposing counsel through her client in response to my motion for visitation.
And that's the only parenting plan we've ever had?
That's the only parenting plan that we've ever had at that point.
And again, all of your motions for visitation occurred after the termination petition was filed.
All motion,
Before.
correct. All motions for visitation occurred after the termination was filed.
And how old was the child when the petition for termination was filed?
The child was born in 2016, and the termination was filed in 2023, so the child would have been 6 going on 7 years old.
I'm not gonna hold you to it exactly, I just was trying to get a timeline.
Anything else?
No, that's-
Thank you, Your Honor.
Thank you, okay. I think we can stand in recess.